I call Julianne Ginter.
Tēnā koe, Mr. Speaker. Tēnā koutou e te whare. I rise to speak on the third reading of the Juries, Jury Service and Protection of Particulars of Jury List Information Amendment Bill. This bill has three main purposes. One is to prevent certain people sentenced to home detention from serving on a jury. The second is to empower registrars to permanently excuse people with chronic ill health, permanent disability, or who are over the age of 65 if they choose to be permanently excused from jury service. And thirdly, it seeks to protect more stringently the address particulars of jurors, which I think is a laudable goal. But I would echo the comments just made by the Honourable Phil Goff, who made quite a great case that actually this bill probably doesn't go far enough in today's world of quick information, and particularly in the context of reducing availability of access to justice, whether that be through the downsizing community law centres or reducing people's availability to access legal aid, will likely result in an increase in the number of defendants who are self-representing, and it is entirely possible that we will see increased occurrences of defendants trying to access jurors, and that's certainly something that we would want to discourage. The other main purpose that I would like to speak to, because it came up and was quite controversial in the committee stages of this bill, was the question of whether or not it was discriminatory to allow people over the age of 65 to be permanently excused from jury service if they elected to be permanently excused. And during that debate, we heard arguments from the Labour Party and the New Zealand First Party that it was discriminatory, but we found it hard to see how it would be discriminatory because it simply gave those people the choice of, they already had the ability to be excused from jury service every single time that they received the call to be on the jury. And at every single occasion, they would have had to apply for dispensation. And so this was giving the registrar the power to say, if those people who had decided that they did not have the capacity or desire or ability to serve on the jury, and the ability to just make that application once and not have to continually send in letters. And also, thanks to the Minister's acceptance of a suggestion that my colleague David Clinton made during his second reading speech, there was the addition to the bill of if somebody had applied for this permanent dispensation from jury service, if they changed their mind, that they could be put back on the roll. We thought that was quite reasonable. But I think that there is a significant public policy question which was raised by some of my colleagues on this side of the House, but it is a separate question, and it is not one that is addressed by this particular bill, and that is, are we doing enough to ensure that the population of New Zealand is able to serve on a jury, that they are empowered to serve on a jury, that it is a thing of civic pride to actually be on a jury. And actually, juries, the right to be judged by a jury of one's peers is fundamental to our concept of democracy. And it is true that as we go forward, as we have an increasingly aging population, as we face all sorts of pressure that families, working adults are under, and they often are unable to serve on a jury because there simply isn't the financial ability for them to take that much time off work. We are going to have to do a lot of thinking as a nation how we make it possible and attractive for people of all ages to serve on juries so that we do continue to have this right to be judged by a jury of our peers. So in conclusion, the Green Party has no problem supporting this bill as it stands. We voted for it at all stages, but we do think that there are going to be challenges that we'll be facing that aren't addressed by this bill, and it is really essential and fundamental to our democracy and the health of our democracy that we find ways of addressing these issues about on the one hand, access to justice, and on the other hand, the attractiveness of jury service to the citizens of New Zealand. Thank you, Mr. Speaker. We commend this bill to the House.
Mr. Speaker.
Call Jamie Lee Ross.
Mr. Speaker.